Coleman has filed a sentencing memorandum as well as a request states motion to accumulate any sentences. Is that correct, Mr.?
That's correct, Judge. I'm inclined to withdraw that motion to you.
Thank you. All right. All right, Mr. Kemmler, you may proceed.
Basically, Your Honor, I would defer to the pre-sentence report. It seems to contain all the information necessary for the court. In my mind, I'm not saying the court is bound to give her probation, but certainly the pre-sentence report certainly would tend, in my
Quiet Texas courtroom. The morning begins with formalities, but tension lingers beneath the surface. Peyton Woodruff, a young woman facing the serious felony charges, stands before the judge, her past now laid bare. The courtroom hears about burglary and robbery, each carrying weighty consequences. Lawyers exchange formal acknowledgments over reports, small corrections, and legal motions. The defense subtly hints at probation, citing her willingness to accept responsibility. This case, however, is more than just paperwork. It's a turning point in a young life. Before we continue, subscribe for more in-depth courtroom stories like this one.
Stay ahead, Judge.
Any additions or corrections to that report?
The only correction I observed, Your Honor, was actually, I think it's a typo where they talk about moral, the MRT program, and they reference it as recognition. I think it's recognition.
Okay.
Misspelled. It's not,
Yeah.
that's, I think that's a problem.
Okay.
Nothing from the state.
And Mr. Coleman has filed a sentencing memorandum as well as a request states motion to accumulate any sentences. Is that correct, Mr.?
That's correct, Judge. I'm inclined to withdraw that motion to you.
The defense attorney Kemmler steps forward, leaning on the pre-sentence report as his foundation. His words paint Peyton not as a hardened criminal, but as someone who has faltered, yet shows rare self-awareness. He stresses her past successes, her candid acknowledgement of mistakes, and her need for change. It's a plea not for absolution, but for opportunity. The underlying message is clear. Prison time may not be the answer here. Across the aisle, the state readies its counter-argument, prepared to focus on the crimes themselves, not the promise of reform. The judge listens, expression unreadable.
Thank you. All right. All right, Mr. Kemmler, you may proceed.
Basically, Your Honor, I would defer to the pre-sentence report. It seems to contain all the information necessary for the court. In my mind, I'm not saying the court is bound to give her probation, but certainly the pre-sentence report certainly would tend, in my reading, to indicate that that would be the appropriate sentence here. I think paramount in that analysis is the defendant's recognition of her failures and acceptance of responsibility, which is clear from
Prosecutor Coleman takes his turn, his tone firm and precise. He details the breadth of Peyton's offenses: burglary, robbery, and drug possession, each a felony. To him, this is not a minor lapse in judgment, but a concentrated episode of criminal behavior. His proposal is strict: 2 years for robbery, 24 months for burglary, to run concurrently. But even as he speaks, there's acknowledgement that this is the minimum, a sentence that still brands her with the lifelong mark of felony convictions. The choice now lies in the judge's hands, where law and mercy must find balance.
Felony offenses of burglary, robbery, 2 possessions of a controlled substance, I think justifies a minimum just sentence of 2 years on the robbery, judge, and a 24-month sentence on the state jail burglary to run concurrently.
The only thing I would observe, Your Honor, obviously that's a minimum sentence, and that would kind of be the easy way out. But the problem with that is it gives her felony convictions.
No, I'm not inclined. I mean, while I agree with Mr. Coleman that this was kind of a lot of things that happened very quickly, the lack of criminal history shows, in my opinion, that things were going on.
The judge leans forward, weighing both arguments. She acknowledges the severity of the crimes, but points to something more: Peyton's complete lack of prior criminal history. To the court, this signals deeper underlying issues: substance abuse and mental health struggles. The judge's voice is measured, but decisive. This will be a case for probation, not prison. A second chance, wrapped in strict conditions. For Peyton, this is a reprieve that few in her position receive. The courtroom air shifts. This is no longer a battle over punishment, but over proving worthiness of the opportunity granted.
With regard to substance abuse and mental health, and I think this is a case that would be, I don't see any reason that there would not be a probation given that opportunity at least. So, Ms. Woodruff, in cause number 24, DCCR 1710, I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation. In that case, that's the burglar of a building, for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation, and I'll talk about those in just a minute. In cause number 25, DCCR 04.
Sentences are read aloud. 5 years. Probation for burglary. 10 years probation for robbery, to fines of $500 each. But the real weight comes in the conditions, substance abuse and mental health assessments. With mandatory treatment if needed, no contact with the victims, no contact with her ex-boyfriend. Named directly in court, the judge's tone is both stern and encouraging. This is a lifeline, but one that can be cut at the first misstep. For Peyton, the stakes are immense. Freedom is now a test, and every decision will determine her future.
To find you guilty, but I'm going to defer all proceedings, place you on probation for 10 years in that case. You're ordered to pay a $500 fine, and you're ordered to follow all of the rules and conditions of probation. You will, when you're on probation, they will do a substance abuse assessment, and then they will recommend whatever treatment. And whatever that treatment is that they recommend, whether it's inpatient, outpatient, if they think you need something, then you will be ordered to do it. Do you understand?
Yes, ma'am.
Also, you'll get a mental health assessment to see if there's anything that you need there to help you be successful. You will be ordered to follow all of those
If
rules.
Peyton violates any part of her probation, the consequences will be swift, up to 20 years in prison for robbery and 2 years for burglary. This is your opportunity not to be a convicted felon, the judge tells her in that moment.
Have no contact with the victims of the offenses. That's a Toni Morrison and Logan Kotlerich. Also, what is the relationship with John Toops?
He is my ex-boyfriend.
He's going to remain your ex-boyfriend. So you will have no contact or communication with him either. Do you understand? And so if you do everything that you're supposed to on these probations, this is an excellent opportunity. You're fairly young, you don't have criminal history. Obviously, you were going through, like I said, substance abuse issues and mental health issues, and you went all in pretty quickly. This is your
The weight of the opportunity and the threat becomes palpable. A slip could erase all leniency. But if she succeeds, the convictions vanish. This is more than a sentence. It's a gamble on human change, with the court itself betting on her rehabilitation.
Somehow, our office has obtained a lab report from that case, but not the actual case referral. About 2 weeks ago, I put in a call to the sheriff's department, the narcotics department there at the sheriff's department. Judge, and apparently returning phone calls is an outdated concept because I've not used the phone call back.
welcome to my world.
Yeah, I was asked to leave a message for Donna in narcotics, and she has today not returned my phone call. So the Jefferson County, BPD, not Sheriff's Department. So the BPD case number is 202414.
As proceedings near their close, loose ends emerge. The state references a pending drug case from July 2024, along with whispers of a March 2025 matter. The defense claims no knowledge of the latter. The judge, almost dryly, remarks on the difficulty of getting responses from law enforcement. These cases could affect Peyton's probation, but for now, they remain unresolved. In a rare moment of procedural humor, the courtroom shares a brief acknowledgement of the bureaucracy's inefficiencies before returning to the business of finalizing Peyton's future. The legal system, like life, is rarely without loose threads.
But it also shows a March of 2025.
I'm not aware of that one. Is there a case number?
No, it's just listed.
I don't have any heartburn over declining that one as well, Judge. I don't have a case number to put on record or anything like that.
Okay, if you'll just kind of watch for it, then we'll hopefully catch it. Y'all can catch it before it.
If the court wants to construe that as an agreement, then we would waive our right to an appeal. If that wants to be, if we have an agreement that they're not going to be.
Well, that's what we would need to change all the paperwork. That's done. I can't imagine that getting a probation, there's going to be an appeal issue anyway. So, all right, good luck to you, ma'am. You can go back with the bailiff.
Thank you, Your Honor.
Yes, ma'am.
The final words are spoken, the prosecution waives the right to appeal, paperwork is confirmed, and Peyton is released back into the custody of the bailiff, not to a prison cell, but to a probationary path. This hearing, though short, may be the defining moment of her life for the court. It's a calculated risk. For Peyton, it's a fragile second chance. Whether she can turn this reprieve into redemption remains to be seen. If you found this story compelling, like the video, subscribe to the channel, and stay tuned for more real courtroom moments brought to life.